Welcome back to Breakfast Central. We start off our top stories this morning here in Nigeria, where the Supreme Court on Monday reserved judgments in the appeals filed by the presidential candidate of the People's Democratic Party, Atiku Abubakar, and that of the Labour Party, Peter Obi. The appeals are challenging the declaration of President Bola Tinubu as the winner of the February 25th presidential elections. Atiku and Obi separately appealed the judgment of the presidential elections, but had their petitions dismissed initially by the Presidential Election Petitions Court in Abuja, upholding the victory of President Bola Tinubu. Marvelous Obomanu was at the court yesterday and tells us more.
On September the 6th, the Presidential Election Petitions Court, sitting in Abuja, Nigeria's capital, upheld the election victory of President Bola Tinubu and dismissed the petitions filed by opposition Labour Party and People's Democratic Party for lacking in merit, and also the inability of the petitioners to bring in verifiable evidence to substantiate their claims that there were wide-range irregularities during the 25th presidential election. Now, at the commencement of the hearing of the appeal at the Supreme Court, the Apex Court dismissed the petition filed by the Allied People's Movement, of course saying that the court had earlier entertained such case, talking about the double nomination of Kashim Shettima. Also, the presidential candidate of the People's Democratic Party has sought the order of the court to tender the new evidence he got from the Chicago State University in his application. The 32-page document was released to the former vice president on the orders of Judge Nancy Maldonado of the District Court of Illinois, Eastern Division, Illinois, United States of America. The U.S. court had ordered the CSU to release the said documents to Atiku, despite Tinubu's objection, because the court was convinced that it would help Atiku establish his allegation of forgery and lying under oath against President Tinubu. However, one of the justices on the panel, Justice Emmanuel Agim, told Atiku's lead counsel that the deposition which is sought to tender as evidence was done in the chamber of a lawyer to Atiku and not in the court as required by law. In his response, Uche submitted that the legal system in the United States is different from that of the English legal system which is practiced in Nigeria, and confirmed that the deposition were made in the law chambers of Atiku's American lawyer with representation by Tinubu's counsels. President Tinubu's lead counsel, Wole Olanipeku, raised an objection to the admissibility of the depositions, saying such depositions have to be adopted by the individual that deposed to it before it can be admitted as evidence before a court of law. The presiding justice, Justice Okoro, observed that the issue of conflicting documents from the same institution is a serious criminal act which ought to be proved beyond reasonable doubt. Now, hearing that application, the court had reserved judgment for the application and other applications and motions filed by the petitioner at a date that will be communicated very soon. Both the presidential candidate of the Labour Party and the People's Democratic Party, including the incumbent president, will all be awaiting the pronouncement of the Supreme Court, which will be coming in few weeks' time. Marvelous Obomanu reporting for News Central.
All right, thanks very much for that report. Pretty detailed there. Loads of Nigerians, actually maybe every Nigerian was anxious about yesterday's court proceedings. But to discuss this further, we're joined by constitutional lawyer Evans Ufeli. Good morning and thanks for joining us.
Good morning.
Great to have you. So I think it's best that we start with some clarity with regards the acceptance of more evidence by the Atiku Abubakar's legal team. Share with us exactly what the court, said yesterday and what it means. Will they be accepting more evidence, or will it, be dismissed?
Well, the court did not disclose whether or not the new evidence or the fresh evidence will be dismissed or accepted. It only went further to talk about the substance of the evidence itself, that there's one of the evidence that is affirming the case and the other stating otherwise. And if the court will have to admit it, it raises another issue of criminality. And that issue of criminality that it raises is something that under our legal system must be proven beyond reasonable doubt. Okay, so can the Supreme Court sit to hear an election petition as a criminal matter? Those are the issues that Justice Okoro raised, okay? So because the truth is that if you are going to talk about criminality in any form, the court cannot admit it hook, line, and sinker, especially when the party under reference have not been prosecuted based on that particular case, based on forgery, and have not been convicted. If it were a judgment, of another court stating that the president forged certificate and the judgment is clear, that means before now, the case has been proven beyond reasonable doubt and judgment has been delivered. But in this case, we are talking about affidavit deposition, and we are talking about allegations of certificate forgery. So if you are raising that issue at the Supreme Court here, and the issue that borders on criminality, which requires proof beyond reasonable doubt, can it be determined in an election petition that is a civil case? Can you impute a criminal case into a civil case, have the criminal aspects of that case determined within the same case, get a judgment within the same case before you now apply the evidence to the election issue? That is what the Supreme Court judge was talking about yesterday. However, we cannot preempt the outcome of this case. The ruling had been sent down. Okay, parties have canvassed their argument, made their points. The applicants have the view that the evidence are, important to their case. They have mentioned it before in the lower court, but they didn't have the evidence then. And by Section 22 of the Supreme Court Act, they ought to admit it because it forms the fulcrum of their case. But conversely, the other side is saying that the respondent, Tinubu, saying that the respondent cannot be dragged into that new evidence should be dismissed, because the 180 days that is required by law for you to conclude your case at the lower court has expired, that the issues of tendering new evidence will amount to reopening the case at the lower court, at the higher court. So arguments have been properly dealt with. Parties have cited copious provisions of the law, the Electoral Act, the Constitution, and other subsidiary legislations, fully and well argued. Now the ball is in the court of the Supreme Court. Now, I need to let Nigeria know that the ruling, this judgment and this ruling that people are calling judgment, is not the judgment on the substantive suit. It's not the judgment on the substantive suit. It's a ruling on whether or not the Supreme Court should admit fresh evidence tendered through a motion or notice by Atiku. Okay? The substantive suit itself is still there between PDP and the president and between Atiku and the president. That one, a date for the judgment of that one has not been stated, because Nigerians are all over the place saying that the Supreme Court have adjourned for judgment. It is not for judgment, it's for ruling on an application. So I just need to make that clear.
Barrister Ufeli, thank you very much for the clarification as to the fact that this is for the ruling. Now we're going to wait for the Supreme Court, the Supreme Court's ruling. Now you did clarify that what the justice did say, what he was saying in his ruling was that you cannot bring a criminal case into a civil matter. Now, we can't preempt the judge, right? We can't preempt the court, rather. We don't know what side or what angle the ruling will eventually lead to. But what would this mean, in the event that the ruling, the court rules that this quote-unquote fresh evidence is not admitted? What would this then mean? Would it mean that the People's Democratic Party would then have to maybe go and institute criminal proceedings, or what would that look like?
No, if the court did not admit the evidence, what it means is that the parties will continue with the evidence already tendered at the court below, because that is what the Supreme Court is supposed to review, the evidence, because the Supreme Court is supposed to look at the case, how it was conducted by the tribunal, and look at the rulings or the judgments made, the laws applied, the judicial precedents applied, and whether the fact of the case, whether the laws were correctly applied to the fact of the case. Okay, that's what the Supreme Court is supposed to do on all the issues of determination. At this level, the Supreme Court is going to look at the grounds of appeal. What were the grounds that what were the grounds that instigated the parties to come to a higher court? Those grounds of appeal, where they are saying that the judge, the petitioner, or the judge erred in law to have held that the following happened and all that. So those grounds of appeal, the court will look at it and look at what the Court of Appeal did at the lower court, whether the laws were applied correctly. Where the laws are applied correctly, they will uphold those areas. Where the laws are applied incorrectly, those areas will be upturned. Okay? And that is exactly what the Supreme Court is going to do. You know that after the matter at the tribunal, there's what they call record of proceedings. All document filed, all processes filed are collated and are transmitted to the Supreme Court. Okay, so then the parties, as they move from the tribunal to the Supreme Court, they also do what we call, they file their appellate brief. Now, this appellate brief is where they take time out to state exactly what the tribunal did, which it did wrong, that made them to come to the Supreme Court. Then the respondent, in this case the president, will be canvassing that the court below did the right thing, applied the law correctly, and that the appeal at this level should be dismissed for lack of merit. Whereas the other side will be saying, should be dismissed. The other side will say, okay, uphold the issue and all that. So these are the issues that are being canvassed at this level.
You know, and also help clarify, you know, are these proceedings time bound? Are we expecting that, you know, they must give a ruling at a certain time? And then also speak about the APM's case, which was thrown out. Some might argue that that was a little unfair, you know, to them, because they feel like they still had a case against the Vice President, Kashim Shettima.
No, the APM case was a pre-election matter, and same have been determined by the courts beneath. Coming to the Supreme Court is just because they have a constitutional right to do so. The fact that you have a constitutional right to exercise does not mean you will succeed at exercising that right, because you have legal constraints too. The matter was statute barred in the first place. APM did not contest the presidential election. And if you look at the Electoral Act is quite very clear to that effect that you don't come that way. Then the pre-election matters the pre-election issues that they had raised all through the case coming from the tribunal were also against them. So it was a good one to discharge them early in the day, so that the Supreme Court, they don't continue to push forth when the court will have to determine serious issues within parties who fall within the law. And as to the time bound, yes, it's time bound. The Supreme Court have 60 days. 60 days from the day the issue was filed, not the day hearing commenced. Okay?
Right.
This matter filed close to a month now. Before it was even opened. So the Supreme Court will barely have 20 days plus or 30 days to determine this case. It is not the law that the Supreme Court must expend the 30 days. It is on or before. So, you know, at this stage, what they are doing is a review. A review. So the Supreme Court will come down with its judgment when it gets to the substantive suit, after determining the motion before it. That is, if another motion is not filed after this one, but the one filed by Atiku is the only pending motion before the Supreme Court, which the Supreme Court have given parties the opportunity to argue yesterday, and parties have done that. Now the ball is left in the Supreme Court to make that ruling known to the public before it delves into the substantive suit.
Right. I mean, we just have to wait as quickly as possible. Having looked through the petitions of, the petition brought forward by the PDP, would you say that this ruling, would you say that this is the strongest point or the strongest argument that the PDP might have in this case?
Yeah, there's a strong argument that the PDP might have in this case because the court itself, okay, the rules of court, the Supreme Court, no, that's not called the rules of court. The rules of court made provision for you to file or to bring a motion on appeal, okay? That is even why filing was even possible in the first place. And then Section 22 of the Supreme Court Act also gives the Supreme Court the power to even rehear a matter that has been heard by lower court. It gives them the power to rehear it. And anything in law that gives you the power to rehear a matter has conferred on you the power to admit evidence. But hearing has to do with telling of evidence. You understand? So the argument canvass, because the evidence itself have not been, this is just a way of tendering it, okay? Even if the Supreme Court admits it, it does not mean the PDP has won, because a lot of Nigerians are just on standby now, okay? And journalists have a way of also publishing this thing to mislead the public. If the Supreme Court grants the motion and that evidence admitted, does not mean the PDP has won the case. Because I know on that day, a lot of people will go here or there. Even the probative value the court will give the evidence is a secondary issue, it's another thing entirely. The court can admit a piece of evidence and not even rely on it.
And it's important that you clarified that, but it's just how you threw my colleagues under the bus, saying that journalists have a way of sensationalizing this. But
I think it's also because of how important these decisions will be, for Nigerians. A lot of people are very anxious to see what the Supreme Court says. Yes. And of course they would see it as either a victory of the court, victory for Nigerians, or maybe also complete defeat of Nigerians. And these things would also tell how much faith Nigerians would have in the legal system going forward, if they would trust that they would always be able to get, justice. But of course, justice has, no business with emotions of anybody. Quickly also speak on the, the story of the FBI documents that are meant to be released also concerning the president.
Yeah, the document have not been released, to the best of my knowledge. They have not been released, so there's little or there's no much to say about it other than that it should be released. But by the time it is released, what use is it going to be? Maybe for other cases, or because for now the president cannot be prosecuted based on any issue that is released that has to do with criminality, except until he serves his term and is no longer the president. By Section 308 of the Constitution, he has that immunity. And internationally, we also have the issue of sovereignty. It's covered by sovereign immunity for international sphere, and by the country's law, it's covered by constitutional immunity. Okay, so all the criminal angle to this case that requires proof beyond reasonable doubt and all that, those issues can only be dealt with after the president has left office.
Well, okay, the argument for and against immunity is one that is an unending one, with many saying that the governor, the president, and all of them should be stripped of the immunity that the Constitution provides, and others would argue against it, saying that it would make available frivolous cases and distract them from governance. But maybe we'll have that conversation on another day. Ufeli, thank you so much for joining us this morning. We look forward to having you again.
You're welcome.